Good afternoon. I am Dr. Chaube, professor at IIMT College of Engineering, Greater Noida. In the course of next 30 minutes or so, I shall be speaking to you about the contract management and ADR. At the outset, let's see what is the meaning of contract management. Contract management essentially involves systematic and efficient management of contract creation, execution, and analysis, with a view to optimize the operational performance, financial performance, and minimize the risk. Now let's see what are the type of tenders. First is the open tender, wherein all eligible tenderers are invited to bid. The second is limited or closed or selective tendering. This process is adopted when there is no sufficient time to go for open tendering, that is large number of tenderers they submit their bids and it takes huge amount of time to carry out tender analysis. So therefore, in such cases we select only a certain number of tenderers, and which is also called closed tendering or limited tendering. Only those who have been invited to submit their bid are asked to apply for issue of tenders and submitting bids. Next we have the single tender. Single tendering is generally avoided as there is no option for any competitive bidding in this case. Only single tenderer applies, and whatever rates he or she would quote will have to be accepted. So this is a riskier business generally, and most cases it is avoided unless there exigencies of services demand so. Next we have the negotiated tendering, wherein certain negotiations are carried out before issue of tender documents, and based on the mutual understanding then the tenders are floated. Next is item rate contract, item rate tender, wherein the list of various activities or various works involved are listed in the tender document in Schedule A, and tenderers are required to quote their rates against each item of work. So this is called item rate tender. There is next one, percentage rate tender, wherein all activities involved in the project. For example, in case of building construction, it will involve construction activities, then road construction, it may be arboriculture, it may be water supply, electric supply, or certain installation of machineries. So varied type of works are involved. So overall, whatever the government rates are there, or the project manager has worked out his or her rates, standard rate, the tenderer is required to quote over and above the rates specified by the tenderer, by the project owner or the government, as the case may be. Then international competitive bidding, when the technology warrants so that the international or global bidding is required, the project owner generally goes for international competitive bidding. Then national competitive bidding, when there is a national interest involved, or the government wants only domestic bidders to bid against the project, then national bidding is resorted to. Then next we have the RFQ, request for quote, which is self-evident that we generally only are interested in quotes, and then based on that we make up our mind whether order to be placed or not. Next we have the RFI, wherein certain informations are solicited, and then EOI or RFP is resorted to, and then single bid tender and two bid tenders. In single bid tenders, the exact scope of work and technical feasibility and financial feasibility both are invited together. But in a two bid tender, first technical feasibility is invited, and only those who submit robust technical solutions are selected and asked to submit their financial bids. Next, we go on to the what are the scope of contract management. Scope of contract management, it involves its manifold activity. It involves technical management, contractual management, legal aspect, financial management, and ethical aspects. Including all these aspects are also equally applicable in case of e-contract management. Technical management requires at places like in case of building construction, we may like to see the mixed design. We may be interested in the cube and block testing or electrical and mechanical testing of certain equipments. In contractual management, we generally ensure that general conditions of contracts are laid down, which are the general and standard conditions in any contract. Then special conditions. In a particular case, certain special conditions may be involved, like working hours may be limited, or maybe restricted area, not everyone is permitted to enter in that area. So any such special conditions, if applicable, are laid down in the contract document. Then particular specification. Tenderer may be interested in a particular type of design, so he or she would mention in the contract document what particular specifications are required to be resorted to while executing the contract. Then schedules are there. Schedules, generally there are three schedules: Schedule A, Schedule B, and Schedule C. Schedule A involves the list of various works that are to be executed. Schedule B involves the certain stores that may have to be issued to the contractor free for fixing, like in case of a building construction, the project owner may be interested in issuing, say, fans or tube lights, or maybe some other electrical equipments or air conditioning equipments from its own available sources. Then Schedule C will be there. Schedule C may be certain tools, equipments, and plants. Like in case of a road construction, the project owner may be interested in supplying his or her own road roller if one has. Then next part will be the drawings, detailed drawings of various stages of work, then layout plan, then acceptance letter, and important letters related to the contract, which might have been exchanged during the contractual process between the contractor and the project owner. Next, we have the legal aspects of business, wherein the government has enacted certain laws related to contract management, such as the Contract Act 1872 or the Sales of Goods Act. So these provisions of these acts are also applicable in contract management. Financial management involves adherence to the GFR 2017, General Financial Rules, then GST, then custom duty rules. So these are financial provisions that are to be adhered to in contract management. E-contract management involves inviting bidders and issuing them password and ID so that they can access the contract document and submit their bids at the given date and time. There is no requirement of bidders to come personally and attend the office. Ethical aspect involves adherence to the provisions of the contract in the contract documents on the part of the bidder as well as the contract project owner. So this is very, very important. Both of them, they discharge their duties as required in the earnest manner, as in the good intention of the execution of contract. Now, what are the activities involved in contract management? Let's see. Certain activities which are supposed to be carried out as part of pre-award activities and then post-award activities. Pre-award activities involves the notice of tender, wherein the project owner invites bids and in the newspaper or various media channels, electronic and print, The details of works are published or printed for the knowledge of all bidders globally or in a domestic, as the case may be, so that large number of tenderers participate in the bidding process. Then preparation and issue / uploading of tender document. After issuing the notice of tender, the project owner prepares the tender documents, and in case of electronic contract management, e-contract management, it is uploaded on the website. Then issue of amendment. Right from the time of uploading until submission of the tender documents, there may be certain amendments required. So all these amendments are duly incorporated and uploaded along with the documents on the website in case of e-contract management, and in case of physical bidding, these are dispatched by post under certificate of posting to the bidders. Then receipt of tender by due date. Tenders are required to submit at the given date, time and place their offers, bids, and then these are opened and scrutinized by the tenderer, and L1 is decided. Then contract negotiations are carried out, and freakish rates identified, wherein sometimes contractor quotes very high rates and sometimes very low rates. So reasons for these have to be identified, and only on satisfactory reply, then these aspects are considered, and final L1 is decided. Award of contract is subject to L1 and the provisions as decided, or procedures as laid down by the department. Then post-award activities involved placing of work order, handing over of site in case of construction management, and commencement of work. The contractor commences the work, issue of material or equipment as per schedule B and C of the contract documents, and insurance of compliance of general conditions of contract, special conditions of contract, and also particular specifications. Then the contract progress of the execution is monitored using CPM or PERT or such other testing technique, such other monitoring tools. Then after completion of the project, testing is done by the competent testing officials, and commissioning is done after tests are found successful, and performance management is ensured. During currency of the contract, whatever provisions have been made regarding the payment to be made to the contractor at various stages of the contract, that schedule is required to be adhered to, that, and that includes also the running payment, then pre-final and final payments, and also retention money, say about 10% towards defect liability period, and certain admissible deductions also are carried out at that stage against issue of certain material free for fixing. Then completion certificate, once the project is completed satisfactorily, tested, commissioned, then completion certificate is issued to the contractor, and defect liability starts from the date of issue of the certificate. And after satisfactory completion of the defect liability period by the contractor, his or her BGB, that is bank guarantee bond, is released. And in case of any let up, the money available in the bank guarantee bond is utilized for discharging the defect liability if the contractor fails to respond. Next, we have the essentials of a successful contract, that is for efficient delivery, service delivery, and value for money realized. It is very important that the supplier or contractors, they cooperate and they are responsive to the need of the department. Organization's understanding of its obligation under the contract it is equally important that the organization or the project owners, they understand their liability or obligations towards the tenderer, towards the contractor, as per provision of the contract. All efforts must be made to avoid disputes, and no surprises should be sprung during the currency of the contract. For example, if the foundation is to be dug and provision is 1.2 meters, say 90 centimeter or 1.2 meter, but it is found that up to the given depth the hard strata is not found, then that means further excavation will be required. Now in that case, the mutual understanding must be developed between the project owner and the contractor, and both of them should agree for special rates, and such deviations must be mutually agreeable, acceptable, and then only should be put into practice. And no undue advantage to be taken by the contractor in such situation. And next we have the professional and objective approach. Changes towards deviations must be adopted by both. This is what exactly it meant, that when some unforeseen situation develops, both, that is the project manager, project owner, and the contractor, must very objectively view it and proceed with the deviation provisions. Then efficiency is the key issue. At no stage efficiency should be discarded, because this runs into the time and cost overrun in the project. Despite best efforts, the disputes may occur. So there has to be provisions in the contract documents to resolve the disputes. Towards dispute, the Government of India has enacted the arbitration and conciliation laws, and the provision of this must be made into the contract documents. There is also a provision of caveat in section 148A of the CPC, which necessitates the formal notification to a court or court officer not to take certain steps till notifier is heard. And to this end, the aggrieved party files the caveat in the appellate court. In case of international bidding, international contracts, the United Nations Commission on International Trade Law, UNCITRAL, has adopted UNCITRAL model law and on international commercial arbitration in 1985, and the rules regarding conciliation have already been promulgated in 1980. Let's just quickly have a look at the Arbitration and Conciliation Act, which has the provision for of appointment of an arbitrator. The appointment is to be made upon request by a party, by the chief or by the chief justice, or any person authorized or institution authorized by the or designated by the chief justice. Then rules of procedures. The arbitral tribunal is not bound by the CPC or Indian Evidence Act. It has to go with its by its practical experiences. Then in case of arbitral award, there is a need of certain amount of interest to be paid on the sum awarded by the arbitral tribunal. A sum as directed to be paid by the arbitral award shall, unless the award otherwise directs, carry an interest of 18% per annum from the date of award to the date of payment. Correction and interpretation. Towards this, within 30 days from the date of receipt of the arbitral award, unless another period of time has been agreed upon by the parties, a party with notice to other party may request the arbitral tribunal to correct any computation error, any clerical error, any typographical error, or any other error of a similar nature found or observed in the award. Application for setting aside arbitral award. If a party is aggrieved with the arbitral award, it can take recourse to a court against the arbitral award, and can in terms of provisions laid down in section 34 of the Arbitration Conciliation Act 1996, and request for appropriate court to set aside the award. The enforcement of the arbitral tribunal is treated to be as if it is the award of a CPC, award of a court, and which is awarded under the Code of Civil Procedure 1908. So it will be treated as a decree of such court, and as per procedure, as per the law laid down in the CPC. As regards the limitation, this Limitation Act 1963, which is applicable in case of court proceedings, shall also hold good in case of arbitral proceedings. Now the situation with regard to reference to any arbitral or judicial proceeding during pendency, when the parties are already undergoing a conciliation proceeding, they are forbidden to initiate any other proceedings, and ensure that this proceeding, once this proceeding is over, then only subject to the time frame laid down in that proceeding, they should proceed with the filing a case in the higher court, and not before that. So making reference to any arbitral judicial proceeding during pendency, not advisable, not permitted. Now let's see certain laws that govern the contract management. In India, we have the Indian Contract Act 1872, which has exhaustive provisions that governs the contract management. Then the Sales of Goods Act 1932, Arbitration and Conciliation Act 1996, the Arbitration Conciliation Amendment Act 2015, Contract Labor Regulation Abolition Act 1970, and various finance laws come into play. Now, in case of international laws, international contracts, international laws come into force, and let's see the US laws, various US laws that govern the international cases. These are US laws. In case of United States, US laws, Equal Pay Act of 1963, Title 7 of 1964 Civil Rights Act, Equal Employment Opportunity Commission, Age Discrimination of Employment Act of 1967, Vocational Rehabilitation Act of 1973, Pregnancy Discrimination Act of 1978, Office of Federal Contract Compliance, the Civil Rights Act of 1991, Burden of Proof of an Employer's Permits Compensatory and Punitive Damages, and Genetic Information and Non-Discrimination Act of 2008. Certain US labor laws also come into force, and these are OSHA, that is Occupational Safety and Health Act, RESHA, that is Radiation Exposure Compensation Act, FECA, that is Federal Employees Compensation Act, and Employee Retirement Income Security Act, ERISA, then Black Lung Benefits, Family and Medical Leave Act, Migration and Seasonal Agricultural Workers Protection Act, Fair Labor Standard Act, which is very akin to our Indian Minimum Wages Act, and Immigration Nationality Act, H2VA, Visa Controlled by Employment and Training Administration, Federal Mine Safety and Health Act. These are the acts which are required to be adhered to. In addition to that, very akin to what we have in India, the Contract Labor Regulation Abolition Act 1970, the US Act of McNamara-O'Hara Service Act is to be obeyed, it's to be followed. Then, similar to our Minimum Wages Act for government construction works, the US Davis-Bacon Act is also applicable in case of international contracts. Now let's see the Pareto and ABC analysis. Applying the Pareto principle to businesses, it helps to separate the vital few, the 20% from the useful many, the other 80%. So that means the top management must concentrate only on the vital few, that is 20% of the activities of any contract management, and the remaining 80% must be left to the supervision and attention of the subordinates. So therefore, during planning execution, managers at all levels must identify those 20% of critical activities and manage themselves personally, and the remaining 80%, these can be delegated to subordinates to retain overall control of the project. Thank you. Thanks a lot.